sentencing?
For sentencing.
Your Honor, you want a pre-sentence report?
Yes, I'm having a PSI report done.
We are not available on the 13th. I believe we could do the 14th.
I'm in trial the week after that, and it does seem to be a little accelerated given the seriousness of the decisions you're about to make. So later in January would be our preference. We also would like to talk about the bail issue too with you before you decide it, before you make a decision to take her in.
All right, I'll hear you out.
Go ahead, no.
Well,
You know, I think it'd be easier for the court reporter if you went to the podium.
I'll go after you. We both say a little bit, Judge.
Yes.
well, there hasn't been a motion. I anticipate they would file a motion, but this arguendo, they're going to file a motion to revoke her bail. We will be filing a motion for a dispositional departure on the case. She is amenable to probation. Her remorse and regret for the incident is overwhelming. She's not a danger to the public whatsoever. She has made all her court appearances, including all appearances in the court. It is the Christmas holiday season. She is a devoted Catholic, no less, and there is no point to incarcerate her at this point in time because A, you haven't decided what the sentence is going to be. B, the dispositional departure arguments are quite strong on this case. And C, it's not necessary for the preservation of public safety. So for those reasons, she need not be incarcerated whatsoever pending sentencing. You certainly can do it after sentencing, but this is a rather unique case of someone who has law enforcement experience and was never in trouble in all her life and is 49, which is beyond the age of most defendants that you see. Plus she has deep roots in the community and her family's here, and there's no evidence that she would flee. So we respectfully ask you to change your mind as to whether she needs to be incarcerated right now. I know Mr. Gray has a couple comments too.
Your Honor, her bail right now is $100,000. She's got that posted. She's not going to run. She obviously is not going to commit any more crimes. She's been convicted of an accident. She's been convicted of being reckless. I just would like to be able to, with Paul, file a motion for dispositional departure in this case. I think there's other facts that didn't come to light during the trial that are important also about Kim Potter and about this case. So I respectfully request that you release her on her $100,000 bail, and that'll make it easier to do the pre-sentence report. We'll get people sending letters on her behalf. And I would ask for the sentencing sometime after, if you release her, sometime. I start a trial January 20th. It should be over by February 20th, I hope, sometime in late February. And ask that my gosh, she's got a $100,000 bail up, Judge. But, she's not going to commit another crime. She's not going anywhere. Thank you.
Okay, Mr. Frank.
Thank you, Your Honor. We do request that the defendant be taken into custody. The convictions here are for manslaughter in the first degree, manslaughter in the second degree, based on the death of Daunte Wright, a young man. In other words, it's a case that involves a death. They are very serious charges. It is customary for defendants to be taken into custody upon a guilty verdicts for those level of crimes, and we don't think this case should be any differently. Your Honor, we also have learned that the defendant is not living in the state. I don't know if that was known and provided for in the original conditions of release, but it presents obviously an aggravating factor for allowing her to remain out of custody. So we are requesting that the state remand her into custody and withdraw any bail or conditions of release. Your Honor, we do have the Blakely issue to resolve, and we would be asking some direction from the court on whether we should submit written arguments or proposed findings, or how the court exactly wants to address that. It would be good to have those findings, of course, for the actual sentencing hearing, and we would request a PSI as well.
Judge, may I respond? Just,
Yes.
it's a serious crime, I understand that, but both of those crimes, there's no intent, no criminal intent. It's reckless and culpable negligence. Many times in my career, I've had defendants convicted of culpable negligence. I don't think I've ever had a reckless one, but it's an unintentional crime by somebody with a clear record, and we have a strong basis for a dispositional departure. I ask the court to release her on the bail. She surely will reappear.
Okay. The presumptive sentences in this case are commits, and I am going to require that she be taken into custody and held without bail. And I recognize your arguments, Mr. Ng and Mr. Gray, but I cannot treat this case any differently than any other case. So, I think we should probably set briefing deadlines. I know that the defense would like to make a written motion for dispositional departure.